Um, Hello from a sunny London and welcome to this Doughty Street Business and Human Rights Roundtable on how do we remedy human rights violations in garment supply chains. My name is Krishnendu Mukherjee. I'm a barrister and Indian advocate at Doughty Street Chambers, and I'm joined by my colleagues Asim Roy, an Indian trade unionist, joining us from Ahmedabad, who co-founded the Asian Floor Wage Alliance. Also Nusrat Uddin, a partner at the London firm Wilson Solicitors, specializing in immigration and business and human rights. And Chris Patz, policy officer with the European Coalition for Corporate Justice and director of the documentary Discount Workers on the struggle for justice of the victims of the Ali Enterprises fire in Karachi in 2012, in which 260 workers died. It's also worth mentioning that we were unable to get a speaker from Boohoo PLC to join the panel today, despite trying very hard. We would have valued the company's response to the independent review released this week, which showed continuing poor conditions in the Leicester garment factories, despite the company's efforts to remedy violations in its own supply chain. I'm sure you're all aware of Zoom, but obviously you're aware that the mics are muted, the videos are off. It's a presetting that that stops any background interference. We are, of course, looking forward to any questions and comments that you might have. Please put the questions and comments either in the Q&A function on your screen or in the chat function on your screen as well. The webinar will be recorded and a copy will be available on our website once we finish for any of the work or any of your colleagues are unable to attend. And there will also be a short survey, I think 3 questions, which will be posted around 10 minutes from the end of the roundtable. So thank you very much for attending. And our first speaker today is Asim Roy from the Asian Floor Workers Alliance, who will talk about the initiatives that campaign is undertaking. Thanks, Asim.
Thank Krishnendu for inviting me to this webinar. It's exciting to be in midst of very eminent, legal activists who have been really involved in the global supply chain, work for a long time. So I'm actually in the International Secretariat and one of the key people, person who has been involved in founding the Asia Floor Wage, which is essentially a labor alliance, labor and social alliance, with the core membership of unions from various garment unions in Asian countries in order to address the wage question, the freedom of association question, and the gender-based violence question in the garment supply chain in Asia. So that's our core area of work. And we have been, we've got involved in the process of formulating a kind of cross-border wage formulation, which is a normative framework for figuring out what should be what would be from a human rights perspective, the living wage in a garment industry. And we have been arguing that such a living wage should be given to the workers, and the workers are entitled to such a wage in the garment supply chain. So that's the core area of our work, and we have been involved for the last 15 years in pushing that idea. And at the moment, we are actually having a far more wider alliance from Asia Floor Wage. It has moved to a European Floor Wage framework, the CCC, the Workers Driven Social Solidarity Network from US, and now there is a Wage Forward campaign to force for a living wage in the garment supply chain. So that's the broad outline of the kind of work that we are involved. Yeah.
Okay. And sorry, do you want to continue and say what the AFWA has been doing?
Well, at the moment, I mean, there's a long history to our work, and I think everyone who's participating here and my colleagues on the panel here also are, deeply involved in this work. And our experience is that for 2 decades, we have been waiting for regulation of this global supply chain. We have been waiting for all kinds of efforts that the industry, the brands have done to see that the workers gets their right. But unfortunately, most of that effort has not really resulted in a tangible results at the level of the workers' own life. In fact, a recent study by the Cornell University showed that more than out of 20,000 audits they had done, there's hardly any substantive change in the last 20 years in the condition of the workers. That shows to the extent that we have been saying that this kind of top-down brand initiative are not going to work. It doesn't mean we don't engage with them. It doesn't mean that we will not deal with them, and we'll kind of still try to convince and be able to engage in any process that they are willing to do it. But essentially, we feel that we need to bring the power back to the global south in so many ways, and basically ensure that the supply chain and the brands are made accountable. So I'll just put it in three brief points here. The first is we do want to kind of debunk this idea that essentially, and the legal fiction that has been created, that as if the brands are buyers and the brands are buyers of product, the brands are in the commodity market. We want to essentially establish in our analysis, both in terms of global supply chain analysis and the legal analysis, shows that no buyer is in the what is called an arm's length market in buying products. They're in the market of production contracts. So essentially what we are saying is that as you shift from a commodity market of products to a production contract, essentially the legal fiction of you being just a buyer has to collapse, and one has to look into the embedded employment contract that is always will be there in any manufacturing process. And so we feel, and our effort is to see that we can make the brands jointly liable in the distinct domains of the national laws in different countries. And at the moment, Asia Pro, which is involved in actually fighting a lot of legal cases to actually argue. And we believe that we'll make some breakthrough that argue that the brands are responsible as production, as one who has entered into a production contract for the employment relationship and clearly for the statutory obligation that come from such an employment relationship. And that if there is a violation of statutory obligation, then brands are also co-responsible. In other words, they're jointly liable for any failure in not providing the statutory rights and statutory wages to the workers. So that's the core level in which we are moving. As the discussion unfolds, I might be able to add more into the questions that come.
Sorry, our audience may be interested in what countries you find
so
joint.
We are at the moment in India, Bangladesh, Pakistan, Sri Lanka in the South Asian region, and we are in Indonesia, Cambodia, in the Southeast Asia region, and we are at the moment beginning to work in Myanmar and Vietnam.
And what has the response been of the courts in those countries?
We have filed almost all countries. We have filed the joint employer liability complaints in at least 3 countries where they have already been entertained by the various jurisdictions and authorities that are dealing with this issue, and we hope to be able to make a breakthrough on that. And we have a strategy. That is the first stage. We do want to move on to a larger question about responsibility in the global supply chain. I know when the discussion takes place about due diligence, so we are going to also kind of enter into that framework as we go forward.
I mean, the crucial problem here is obviously that the courts generally treat brands, buyers, and suppliers as 2 separate legal entities. And obviously they say that the buyers don't have any legal responsibility to what goes on in the supplier factories. That's obviously been a principle of commercial law for hundreds of years. How do you get beyond that in your cases?
See, yes, I agree, and that's a legal challenge that we have to overcome, and that's why we essentially want to move from the framework of that to viewing it as a commercial contract, which is just a contract to buy products, to a framework where we want to say that if you have a production contract, the terms of the production contract, and we have some production contract with us, if the terms of it are so extensive that you can't even sell the product outside the permission of the brands, even if they're wasted, even if they're faulted. There are many criteria. I don't want to go into elaborate process here, but essentially what if the terms of the production contract are examined from a legal point of view, all the elements of what is called the organizational test, all the tests of supervision and control will at least be there in relationship to the workers in this country, except for the dispensation of the wages, which is done by the employer or the supplier. Every other terms of the production, that means the full production and the full work content, the work process, the work output, all these are controlled by the contract that they have got into. In minute detail, how many stitches per buttonhole, what should be the length of the stitches. All these are actually so detailed in the production contract that one has no other leeway but to say that they are in full charge of the production. Now, if they're in full charge of the production, our question is, who becomes responsible for the employment contract? And we can argue, and we can as we develop this, we don't want to argue that we are only the sole employer of our sole employer is the supplier, now is the brand, because that would be stretching it too much. But we do want to show that in the global supply chain, the employer-employee functions are distributed. And if they are distributed, the law has to begin to recognize that distribution. And so a joint liability has to be the framework in which you take different functions of an employer-employee relationship, which the employer has, and attribute them responsibility. And so the responsibility of whatever failure takes place is also partly on them. So that's the broad tenor of our strategic trajectory of our operation.
Okay. Thank you very much, Asim. I think with that, we'll move on to Nusrat, who I think has a presentation. Nusrat has been working on taking a claim, she'll obviously tell us about it, against the British government here for violations that have occurred abroad, and also the issues in the Leicester garment factory. So Nusrat, do you want to begin your presentation?
Yes, I'm just going to attempt to share my screen, hopefully. Can everybody see that? Great. Okay, let me just... Okay, so yeah, hi everybody. My name is Nusrat Uddin. I'm a partner here in Wilson Solicitors Public Law Department. So we have a history of working with the migrant population here in the UK. We are London based, but I've been recently working on kind of wider issues in terms of our clients, specializing in modern slavery and trafficking. My background is working with victims of trafficking here in the UK. But actually seeing how the government's responses have been in the way they treat victims of trafficking and modern slavery, and the legislation, particularly the Modern Slavery Act, has led my work to look at more further afield in terms of supply chains and modern slavery issues there. So I'm going to talk a little bit about a case that I've got against the government, which isn't directly in relation to the garments industry, but I will take you on a bit of a detour, hopefully, to come back to the garments industry and how it might be relevant. Because I mean, the global garments industry is extremely diverse, and the picture on the ground for each country and each even areas within a country will be very different. So there will be, there needs to be a very diverse approach to these very diverse situations. Yeah. So first of all, I mean, I'm going to focus mostly from a UK perspective, what we've been doing here. So the Modern Slavery Act was introduced in 2015 here. There was a lot of fanfare around it being world leading and the first piece of legislation from a government to talk about due diligence in the supply chains in relation to modern slavery. In reality, it fell very short. The only requirements were to produce a modern slavery statement, and the requirements of what the contents of that modern slavery statement were very, very weak. And indeed, a lot of the reports that have been filed since the Modern Slavery Act about the impact of this piece of legislation has showed that it's really had very little impact in improving behaviours for companies, and actually many companies have not even produced a modern slavery statement as they should have. So this was kind of where my outrage in relation to how the government is putting itself out there in terms of being world leading in the fight against modern slavery, and how in reality it fell very short. And this example of this case is one where we felt it was a really good example to really highlight the government's own inadequacy in its response to modern slavery. So the history of abuse in PPE production of gloves in Malaysia is very, very well documented. The BMA, which is the British Medical Association, produced their own report back in 2016, and I've quoted some of the points they came out with, and this is, you know, more than 5 years ago, but actually the issues go back way further than that. So we're talking about long hours that they're working. My clients, some of them were working 12 or 14 hours during the pandemic, 7 days a week. Their breaks consisted of a half an hour lunch break, a 15-minute break in the morning, and a 15-minute break in the evening. So over a 12 to 14 day working day, that's an incredibly short amount of time. You can imagine a lunch break of half an hour. You know, by the time you've washed up and, you know, pop to the loo, to actually then eat a meal and get any kind of a break is extremely rushed. They're working in extreme temperatures, very little protection from the chemicals that they're exposed to. They're expected to live on the premises of the factory. There are hostels that have been built, many floors, open 3-level bunk beds, with rows and rows of workers, no privacy for them to sleep in, very, very unsanitary and you know, dire conditions that they're working in, paid, you know, the equivalent of £1 an hour, whereas you had these huge PPE glove producers who through the pandemic have, you know, doubled their profit margins at the real detriment of the workers. So what we've done, well, what Andy Hall, migrants activist, has done has really exposed the issues in Malaysia, in particular in this industry. And by working on the ground with, you know, with individuals who are embedded in the correct communities of the workers, and built that trust in order for them to come forward and talk to those individuals about what's really been happening on the ground. And what they've used in the Malaysian industry is the US Customs and Borders have a law where they can actually ban products being imported into the US on the basis of those products having modern slavery within their supply chain. And so what Andy Hall has been able to do is to make these petitions to the US and have several of these glove companies actually banned from the US. We saw Top Glove initially back in 2020 banned, and that was the first one and one of the top 3 in Malaysia. And then we've had since then, we've had 5 or 6 others. So you can imagine the US being a huge, you know, market for these products, and the banning of those imports has had a significant effect on these companies, which has made them really rethink their, you know, their treatment of their workers. And what you're seeing is almost a domino effect in Malaysia in this one particular industry, where the companies are are understanding that they, need to change their practices and are improving, so that hopefully by the time the US get to investigate them, there is a new kind of industry norm where the kind of behaviors that the US have identified in their investigation are avoided. One of the huge ones being recruitment fees that workers are expected to pay in order to be to get the jobs from their countries of origin, usually Bangladesh and Nepal. So why I'm talking about this firstly is because the US CBP bans in this industry have been extremely effective, and are an example of one mechanism that can be used to really hit a company's bottom line. And I think the legal pessimistic side of me, unfortunately, believes that without this kind of hitting their bottom line, without hitting their profits, they don't take these changes as seriously enough. So what we've done here in the UK is really contrasted the approach of the US with the approach of the UK government, because the UK government, the NHS here, have continued to procure these gloves that are known to be made in Malaysia with these modern slavery issues well documented, and even after the specific company that we're dealing with is the Supermax, because Supermax has a subsidiary called Supermax Limited, and that's the UK subsidiary, which makes it very easy to show a clear chain of command. And Supermax Limited is a direct provider to the NHS here in the UK. I mean, that's another real issue in this field about establishing these chains of command. So, a lot of these brands, a lot of these companies are having very convoluted supply chains from factory to actual supply. So it's really hard to map where the products that are being bought are actually being produced. So Supermax was a really good example for us because they had a UK subsidiary here, clearly labelled as Supermax Limited. So Supermax Limited, so Supermax conglomerate in Malaysia was banned back in the autumn of 2021, and very quickly after that, it's quite soon after that, the government's NHS supply chains contracts were up for renewal, and Supermax Limited, the UK subsidiary, was still granted a place on the NHS framework as one of the suppliers for these PPE gloves, which is hugely problematic, considering the UK has its own legislation, not the Modern Slavery Act, but actually separate to the Modern Slavery Act, called the Public Contracts Regulations. And within that is the considerations that all government bodies should be having in relation to any procurement, any purchase of products, which includes due diligence in relation to modern slavery. So if we have on one side the US's investigation that's found, like I showed on the slide before, 10 out of 11 of the ILO indicators of forced labour, it's very concerning that a couple of months later, the UK government's only processes in terms of due diligence found, no issues, and not enough issues certainly, for them to cancel or not renew those contracts with their UK subsidiary. So our case is a case against the UK government here for that decision to continue to purchase from this particular supplier, and it's the first case to challenge the UK government's own procurement processes in relation to modern slavery. And for that reason, it was quite a risky kind of new angle we were taking in terms of litigation. And we weren't sure if the courts would be receptive to it. But thankfully, last month, we got the first stage of what's called a judicial review. So that's a challenge of a public body's decision here in the UK court. And that's the stage where the judge will grant us permission to proceed with the claim if they agree there is an arguable case to be made. And indeed, the judge's own comments said that there was an arguable claim of grave breach of public law and obligations. So that's really, a really good indication that here the courts are appreciating that there is an issue here and there is an arguable case here to be heard. The next stage will be a substantive hearing. That's when it will, all the evidence will be heard, and it will be decided as to, the judge will decide as to whether the decision to continue these contracts was actually unlawful. So from our perspective, I feel like this is another angle in terms of, for us in the UK certainly, to really challenge the government's approach to dealing with modern slavery in the supply chain. First of all, in terms of highlighting the issues in the Modern Slavery Act, but also in terms of their own procurement, which is, incredibly shocking, considering they put themselves out there as being so world leading. And actually, what's also shocking is what's happening here in the garments industry, in the UK. Not a country that again puts itself out there as being world leading, but actually has issues in the garments factories right on its own shores. So you'll all have heard of the issues in terms of the Boohoo scandal, but Leicester has been known for their garments industry for decades, and these issues aren't new. They're not, and they're definitely not just Boohoo, and it's a real range of failings that must have happened from a central government perspective, but also a local government perspective, that led to this going on for the past few decades. What's different about the Boohoo scandal is the amount of publicity it got and how much it's been highlighted. The fact that there was this public inquiry into it all, and a really helpful report from Alison Levitt QC, which was commissioned by Boohoo themselves. But what that report really highlights, and coming back to what Asim was saying, was how much the directors in terms of Boohoo really knew about what was going on in the factories. It's very clear that they weren't just purchasing these end products. They were very much involved, potentially earlier, according to this report. And what that suggests, like Asim was saying, is that there really does need to be this extension of duty of care, not just to, that direct relationship between employer and employee. I bring cases in the employment tribunal for victims of modern slavery against their traffickers. And it's very clear in the employment tribunals, if there's not an employment contract, then there's no claim. You won't even get through the first hurdle. But in a civil claim, there is things such as implied duties as well. And I think it's arguable that there was certainly an implied duty here in terms of Boohoo. And indeed, I have a client that was working in Boohoo and was picked up by the authorities back in 2020 at the height, in the summer, at the height of when this was all being exposed. And he was picked up by the police because he had a fake document, which is very, very common for victims of trafficking to be given fake documents by their traffickers, which is exactly what happened in my client's case. And instead of the authorities realizing this is a potential victim of trafficking here, in the background of this whole scandal, he was arrested as an illegal immigrant. He was detained and prosecuted and taken to an immigration detention center after serving his sentence in prison. We were able to get him out of detention and are now representing him in taking his case forward. But it really highlights the failures of the authorities in this as well, and really the public authorities' duties that play a part on the ground as well. And yeah, these issues are still continuing now in terms of the Leicester garments industry. A report only just published this week highlighted that. And myself and others are still very much involved in Leicester. I'm working with an organisation called Justice in Fashion, who have been doing some incredible work in Leicester in terms of building trust with the workers there, because it really does need a bottom-up approach in order for workers to ensure that they can come forward and know what their entitlements and their rights are. There's been a lot of investment by brands into the community in Leicester, and unfortunately it's difficult when brands do that, because there's obviously, to some extent, always going to be self-interest in that, and it kind of taints a space if in making a space open to workers if they know actually potential brands are behind that space. So Justice in Fashion is doing some incredible work to try and create a space that's safe for workers to come forward to talk about issues, and to really ensure that they're able to know what their rights are. And there's also a, coming back to the US's approach, there's also a complaint outstanding at the moment with the US Customs and Border Patrol about Boohoo products and also Leicester made garments. It's an organisation called Freedom United has put together that complaint, and it's still very much being investigated. I mean, these investigations take months, as they should do, because that's what real due diligence should take. And coming back to the approach of the government in the Malaysia case, what we're challenging in terms of the government's approach was that the approach was, it seems, much of a tick box exercise in terms of asking the companies, what are they doing about modern slavery in the supply chain. But actually, what's needed is going much further than just a tick box exercise. There really needs to be verification. You can't just take a company's word at it. There needs to be a multifaceted approach to an investigation in terms of what is happening on the ground, and working with migrant activists on the ground, such as Andy Hall, who I mentioned, in order to get a real perspective. But like I said, it's a very diverse range of issues across the world, and every community is going to be different, and every approach is going to be different. So I'm just suggesting some of the mechanisms that we've been looking at Wilson's here in my team. But for example, the Uyghur issues in China, that's it's gone past forced labor. That is on the level of a genocide, and actually getting any information in terms of what's happening on the ground is very difficult. I mean, the US has banned all cotton products from the Xinjiang region, so that is impacting the garments industry. But there's a lot more work to be done, and really, like Hassan said, there needs to be that further duty of care further down the line.
Thank you very much, Nusrat. That was informative, inspiring. So thank you for that. And
I'm going to just try and stop sharing. Bear with me. Thank you. Yeah, I've done that.
And we know that, I mean, obviously you talked about the banning of goods produced by forced labor, by child labor, and also the concept of due diligence. And Chris in Brussels has been working on campaigning for the most effective laws in the EU, the corporate sustainability due diligence proposal, and also the one banning goods produced by forced and child labour into the EU. And I was wondering whether you could talk about what's been happening in relation to those proposals, and how they might affect the horrible violations that we're hearing about in the garment industries.
Great, happy to. Yeah, thanks, Krishnendu, and thanks also for the opportunity to speak and have this table together with Ashim and Nusrat. It's really great to have these exchanges amongst advocates and hear different stories and ways of approaching these common problems. It's really quite inspiring. I'll just start by posting some links in the chat, and if people are interested, they can follow up on some of these key resources. First of all, there is, as you mentioned, Krishnendu, the Commission's proposal. The European Commission has come with a proposal for an EU-wide supply chain due diligence or value chain due diligence and corporate accountability read civil liability proposal. Underneath that, you have our European Coalition for Corporate Justice legal analysis in response to that proposal, if you're interested in going into a bit more detail. Then thirdly, there's the ECCJ member in the UK, and probably quite familiar to a lot of people on this call, the UK Civil Society campaign demands for UK due diligence law, of course, chaperoned by the Corporate Justice Coalition in the UK. Just as well there, a comparison table of existing supply chain laws and proposals, which we found quite useful in our advocacy, which we've put together. And lastly, as well, the trailer to the film, which you mentioned, Krishnendu, that I had worked on together with Pakistani colleagues on the Ali Enterprise case. So I will respond to both some of the issues or give our analysis and rundown of the European Commission's proposal for a due diligence law in light of what Ashim and Nusrat have sort of spoken about already, with a focus on textile supply chains and issues specific to this sector, because of course the Commission's proposal does go beyond just the textile sector or indeed commodities. There are implications for finance sector, for also for as an issue for climate and directors' duties, so corporate governance, which we of course hope to strengthen. If you're interested in those pieces, they are of course covered in the analysis in the second link, which I've just shared. Ashim mentioned the importance of contracts, and this, I love this phrase that he said, you know, the legal fiction that European brands are simply buyers. This is so great, and I just wanted to share, you know, what the German textile brand KiK, which itself stands for Kunde ist König, or customer is king. The argument, the legal argument and the public argument they were making when they were pulled before German courts by Pakistani workers in a civil suit. KiK, the textile brand, was saying, or using the analogy, if you go and buy a loaf of bread from a bakery and the bakery burns down, why on earth would you be considered liable? Appealing to a customer's or a consumer's sense of duty or obligation. And this analogy is, of course, a complete fiction. It's a completely false analogy. A better analogy is that, in fact, a boss, a supermarket chain, which is buying from this bakery and is dictating all the terms of the production in its contract. When you go and buy a loaf of bread, of course, there's an oral contract, there are implicit, you know, by the laws of contract, you know, you have your consumer rights and such. But when we're talking about the relationship between these very powerful brands and these very weak in terms of market power factories in South Asia and elsewhere, it really is a completely different relationship. And that is a relationship that has, of course, been acknowledged as being very special and requiring specific obligations since 2011 with the passage of the UNGPs, and reinforced in 2017 with the OECD guidance on due diligence, which elaborates in 70-odd pages what this power imbalance implies in terms of responsibilities on the side of parent companies vis-a-vis subsidiaries, and of course lead companies vis-a-vis their entire supply chains. So two things are particularly relevant when we're looking at the European Commission's proposal in this context. First of all, we can notice that the European Commission has reduced the conceptualization of due diligence, which is very broad in the international standards, to effectively 5 subsets of actions: a prevention plan, the use of leverage or cooperating with buyers, as well as contract cascading, codes of conduct in contracts, which are then meant to be cascaded. So you get your supplier to put a code of conduct in your contract, or rather you put it in your contract with your supplier, and then you oblige them to put that code of conduct in their contract with their supplier ad infinitum. And then you are meant to get these contracts, these codes of conduct, which are in the private contracts, audited by a third-party audit company. Now, to those of us who have been around long enough, know this scheme and know that it has, to a large degree, not resulted in qualitative change, substantive change in the past 10 years. This is a mechanism which many companies already employ in their supply chains. Ashim mentioned, I think, a number of thousands of audits, a study which has shown, over various countries that these have not led to any substantive improvements. That is not a surprise to anybody who's been paying attention. So we are quite concerned that the European Commission's proposal, in a way, seems to prioritize this so-called means of due diligence, codes of conduct, contract cascading, and third-party audits. How does the European Commission's proposal prioritize this as a particularly specific due diligence measure? As I mentioned, it's one of a number, exclusive list of 5 measures to be taken. We want that list to be broad. We want that to be an indicative list, because we want to promote innovations in responsible business conduct. We all know, as soon as you specify specific things to be done in a law, that is the bare minimum. And in-house counsel will advise the board to do exactly that. So we've gone from, these brilliant and beautiful international standards that took many years to develop, and they're actually quite good. And then we reduce them to more or less contract cascading and codes of conduct again. The other way in which the contract cascading codes of conduct audited approach is prioritized in the Commission's proposal is that it is afforded the status of a civil liability defense. To our a great success in the Commission's proposal is that there is really a quite developed civil liability, supply chain civil liability regime in Article 22, which not only provides for civil liability for controlled entities or subsidiaries, but also for harm occasioned by indirect or non-direct business relationships. Now, there's a defense for companies. If they have done this contract cascading, codes of conduct, and if it was reasonable to rely on that code of conduct approach, then they have a clear defense there. We don't like this measure in the sense, of course, from the get-go, because it's providing a sort of a sui generis defense for companies in a civil liability context. We prefer to have defenses that are based on all the reasonable measures that a company could have taken or should have taken indeed, and not to single out this specific measure. I would highlight here, it would be a different story if these codes of conduct, contracts cascading, third-party audits approach had worked. Then indeed we might want that, and it could be justified for that to be a defense, but indeed it hasn't, and the proof is in the pudding. So that is a concern. That is a very specific concern as regards the textile sector and, of course, other commodity sectors as well. Something else of concern and concerning the power imbalance between European textile companies and their South Asian suppliers is something that was picked up in the European Parliament's position in its report of what a due diligence law should look like, and which is sadly absent from the Commission's actual proposal. And that is the highlighting of the role of purchasing practices. The European Parliament made it clear that doing due diligence means identifying the risks to human rights and the environment that are generated by a company's own purchasing practices. How do you expect a SME in Pakistan or India or Bangladesh to comply with your code of conduct in your contract that you're auditing if they do not have the money to pay for the improvements to the factory? Moreover, how are they meant to comply with labor standards when we have conditions the likes of which Nusrat just explained in her presentation? We're talking about the right on behalf of the contract giver to change an order of 10,000 units of what be it gloves, t-shirts or otherwise with a month's notice or 2 weeks notice. I want to change the color, the size, the whatever. It's as if these companies are operating with no awareness at all for the implications of the contracts which they're writing. And I love again Ashim's sort of his statement that we need to do away with this legal fiction of a company as just a buyer, as just a consumer. They're not. They are powerful market actors whose dictations in contracts have real world impacts. So the good thing about the Parliament's approach was to say that that's an explicit duty within the duty to do due diligence, is to make sure that your purchasing practices do not cause, contribute, or otherwise be linked to adverse impacts throughout your supply chain. So we need to get that back into the Commission's proposal in the ongoing legislative process. The last thing that I would speak to as regards the Commission's proposal, and also in light of the KiK case from Pakistan and the judicial experiences or examples which Nusrat has given us as well, are the access to justice provisions of the Commission's proposal. We have no effective amendments to the burden of proof in these types of cases proposed by the Commission. If we have a due diligence defense, which is provided for a company, then it seems to be that the obligation to prove the adequacy or inadequacy of the due diligence measures, as well as the causation thereof to the harm suffered by the claimants, lies on the victims. Now, in certain circumstances, this is going to require scientific studies. In the case of the Ali Enterprise fire, it required expensive studies into the building structure. And I might plug here a fantastic video done by Forensic Architecture, UK based, on the aftermath or the lead up, I should say, gathering the evidence to the Ali Enterprise fire, really going through systematically based on all the records kept about the building and sort of modeling how the fire spread through and what the effect that a single fire alarm would have had on the outcome of that fire. This is extremely expensive. In this case, it was pro bono, provided by Forensic Architecture. But these types of cases are expensive. And they involve a huge amount of evidence, which is in the possession of the company itself. So without an effective reversal of the burden of proof in such cases, which is politically unappetizing, we don't say the reversal of the burden of proof, we say a fair distribution of the burden of proof. What we may also consider are things such as, discovery rules or evidence rules that are favorable to the claimants. I understand in the UK, these are actually quite good as a matter of course, but in civil law jurisdictions, of course, they can be significantly better on the continent. I'll leave it there because there's probably time for a few questions and discussion, but I would just make a last reference, considering it's been raised so far, the US import ban trade measure for forced labor goods. This is indeed a proposal that we hope to see from the European Commission in the coming months. The European Commission has publicly stated that it favors a product withdrawal mechanism and not an import ban. The European Parliament just last Tuesday voted on a resolution calling for an import ban proper and criticizing the European Commission's approach, which would first of all allow the products onto the internal common market and then have them taken off, which is, of course, for many reasons, ridiculous. So we meant to be going into shops and perhaps even people's houses and confiscating the goods that were taken. It doesn't make any sense. We have highlighted, or the European Parliament, I should say, has also highlighted the importance of using such a trade tool, an import ban, to spur remediation, as has been the case in, I believe, the Malaysian glove case, sourcing or providing for a US company, but perhaps Nusrat can inform us more about that case study. Thanks a lot.
Thanks a lot, Chris. That's really, really interesting. I just wonder, one of the questions is in relation to the definition of due diligence. I was wondering whether you could provide the audience with a definition.
I can indeed. Sorry, I realized I'd posted the links in the, I've posted them in the chat to everybody now. So the definition of due diligence, if you are, so the Commission's proposal in the first link, you can find the definition in Articles 7 and 8, what the specific due diligence measures that are highlighted by the Commission. From memory, the first is a prevention action plan or a corrective action plan. The second, this is in no particular order. The second is the use of leverage, otherwise formulated in the proposal as collaboration with other business entities. And the third was codes of conduct, contract cascaded, and then third-party verified. Another measure, which is really quite positive, which is in there, is the explicit requirement, where relevant, to invest in the supply chain to ensure compliance with the codes of conduct. That is very positive, and I should have mentioned that. But in addition to that, we need to consider what there is the absence of, and that is the purchasing practices, which I had mentioned, which are not in the definition of due diligence. But yeah, thank you. So again, Articles 7 and 8 in the Commission's proposal is where the due diligence obligation is elaborated.
Brilliant. And I think just a follow-up question. I mean, you were very critical of the Commission's proposals in relation to code of conduct, cascading contracts, and auditing. But I mean, what would you put in its place, and how would you protect? And there's a question on essentially on human rights defenders or people complaining. And obviously we know, and I'm sure Ashim can share many examples of workers who've been victimized, especially in the context of South Asia, for making complaints. I mean, how would you ensure that those who are making complaints, which should be acted upon by suppliers and buyers, can be protected?
It's a great question, and I can answer it very quickly. That in the place, or the prioritization afforded to codes of conduct and contracts, we would rather see the prioritization of a stakeholder obligation, stakeholder consultation obligation. You need to have, as a European company, a direct line to people like Ashim and his colleagues on the factory floor. You need to be asking those guys directly, rather than your auditors and the managers of your supplier, what are the human rights risks in the factory? And as you have mentioned, Krishnendu, we need the same sorts of guarantees that we have in whistleblower legislation. We need for these types of channels of communication to be anonymized at the option of the complainant, as well as confidential. So that's what we would like to see prioritized as a means of due diligence, as opposed to a contract privatized audit system, is stakeholder consultation.
Brilliant. There's a question for Nusrat. Does Nusrat know whether there are any procedures for blocking imports into the UK similar to the WRO mechanism in the US? And another question, which is, do you think the UK government has the political will and allocation resources needed to meaningfully address systematic inequalities in Leicester? And
Sorry, say that second one again. Sorry,
do you think that the UK government has the political will and allocation of resources needed to meaningfully address systemic inequalities in Leicester and in the UK-based garment supply chain?
Thanks. Yeah, no, at present, in terms of the first question, there's no imports bans mechanism here in the UK. It is something that I believe there was some litigation requesting something to be put in place in relation to the Uyghur issues, a specific ban of Uyghur products. I'm not sure where that litigation got to, but certainly in terms of law as it stands at present, there is no such ban, and that's why it's such a contrast between the UK and US's approaches. And indeed, the UK's Modern Slavery Act is very weak. There isn't really any real due diligence. The modern slavery statements that have to be produced, they're voluntary. Even when they aren't produced, nobody's holding them to account. I think it's something like 1 in 4, or oh no, sorry, 1 in 10 of who were supposed to be reporting actually reported. And there's no consequences. There's no consequences of failing to produce a statement, because no one's being taken to court to produce a statement. There's no consequences of not having adequate safeguards there. There's no effective mechanism or of objective evaluation of a modern slavery statement. Even if someone's done a good job, nobody can effectively have an objective assessment of whether that is a good job, because there's no guidance on that. So it's extremely, extremely weak. And really, when we've got all of these pieces of legislation that are coming out, the US, Canada, Australia, the EU now, we're not seeing that same response from the UK. And so in terms of the second question, it really is questionable about what the political appetite really is. There's a lot of hot air, there's a lot of talk, but when we see the reality of what is being put forward in law and what is being done in practice, it's not adequate. And in terms of Leicester specifically, what I've said in terms of it's been going on for years, Boohoo has been targeted, rightly or wrongly been targeted as one company to kind of make an example of, in the hope that it then goes away, but it hasn't. It's still continuing, and that really needs a multi-agency approach, like I said, from the local authorities who are, supporting those those children of those migrant workers in those communities, from the police who are making those inquiries of the factories in those raids, and are not aware of what's going on clearly because they're arresting victims. From the fire brigades, I've heard something about the fire brigades know that it's a no-go zone in the factory quarter of Leicester, because they've been told that, you just don't go there. In terms of, it feels like the authorities to some extent have to have been complicit in knowing what's been going on for years. Otherwise it wouldn't have continued. And it still is. We're nearly 2 years on from that exposure. Again, there's been lots of talk, but on the ground, and lots of investment again from the brands, but on the ground, things aren't changing. And that's why, we're working with more grassroots organizations. It's not going to change overnight. But there's a real opportunity there. There is a real opportunity, especially in terms of this public inquiry that happened, showing how much the brands knew about what's going on in the factory. The potential of extending that legal duty, which is really required.
Would you like to see the public sector brought into a due diligence law of the type that's being contemplated for private enterprises in Europe, with sanctions and potentially criminal prosecution?
Yeah, I mean, I'd love there just to be the start of that due diligence legislation in the first place. We haven't even got that here. The Modern Slavery Act is being extended, so public authorities will now be required to produce those modern slavery statements. But again, that's not good enough. It's not. I could literally write a modern slavery statement that says, I am doing nothing about modern slavery in West supply chain, and I have legally fulfilled everything that is required, because all that statement is, all the legal requirement is to tell the government what they are doing about modern slavery. If they're doing nothing, there's no consequence of that. So yeah, I would like some real due diligence laws to be put together in the UK. That would be the first step.
Brilliant. And Asim, I mean, obviously you're in contact with many trade unions working for workers in supplier countries. And what steps would you like to see brands taking to improve the conditions of workers in those factories?
First, let me say I really Chris's presentation on the due vigilance was excellent. I really feel that we need to have more of these to really understand the complementarity of what the due diligence approach from a top-down, from northern countries, and how that can help in actually creating some pressures and creating legislative change, as well as and reinterpretation of laws at the local level in the south. See, our core interest is that we bring back the power of law back to the unions so that they can actually read things into the employment contract. So that's been our core concern, and naturally coming from a workers' perspective and a union perspective, we chose the employment law as the domain in which our intervention was strategized. But I think this is a complementary to a larger framework of how the human rights approach and the due diligence in some form has pushed this idea from in the global supply chain. I absolutely share with Chris the idea. Essentially, both these approaches reject this idea of a cascading code of conduct, verifiable or audit approach. This approach acts essentially at the core level, both the approach from reading the joint liability in the employment contract to the due vigilance expansion of how one would see that it's implemented as it moves down in terms of responsibility. They I feel are complementary each other, and I think that's the very most important part. I do agree that one of the most powerful points that I think has been, like Chris has already said, a certain amount of the shifting of the burden of proof, and I like the phrase of fair distribution of the burden of proof, is going to be an immensely important part. I think that will be, if that comes up within the larger framework of due vigilance, it will help the movement in the ground to really be able to actually allow the shift at the ground level to happen. Like in case of India, in case of Sri Lanka, and I think it's also partly true in Pakistan, though I think in the Pakistan, the higher court jurisdiction has taken a much more of a public interest litigation framework. But in this, the employment law can be shifted. We have a very strong industrial jurisprudence framework. So, a larger framework of this kind would really help both in trying to get legislative framework in the supplier countries to also adjust to this new due diligence framework. So I really feel I'm really looking forward to learning more about the far more nitty-gritty and the details of this, so that there can be a more global convergence of how we really shape the top-down approach and the bottom-up approach on the global supply chain. And that's where I think the unity of the labor movement, the unity of human rights activists, both in the North and the South, can actually come to a far more powerful convergence than anything else. And I'm looking really, really forward to such conversation and, and common actions together on this. So thanks for calling me again to this kind of interesting.
Fantastic. And we just have maybe, just because we started a bit late, just time for one last question, if I'm going to abuse your time. And Chris, you can obviously make your comment at that, which is, what's the role of the investors? And I'd add to that, what's the role of the consumer? Because obviously consumers play a big part in this. And, people are very critical of consumers that buy fast fashion at prices that means that workers don't get a fair wage and their rights are abused. What role do these two important sectors have in improving violation, remedying?
I will leave the consumer part to both Chris and Nusrat, but we have done a study, and we have not yet released it. We have done a study and looking at what are the brands involved in the buyback arrangement of buying their own shares. And it is shocking to the extent of what this data and this analysis shows, that essentially the whole of the brand's world and the brand's financial system is not geared to really delivering to either the consumer or to, for that matter, to worker in any shape. They're more interested in seeing that the share price is sustained at a certain level. And there are enough studies on that and enough data analysis on that. So I really think, and this is something we are actually engaging. The Global Labor Justice Group in US is actually convening a group around the question of financial market and the financial investment sector to understand how we can also have open up another line of what I would call a line of attack to make the brands push from or move from this shareholder framework to a much more stronger on the stakeholder framework approach, And I think that cannot be done by just kind of moving within the stakeholder approach. We have to also kind of intervene. And again, this is where the ground and the top of the global supply chain actors can come together to intervene in the financial markets. And there are lots of human experience and capital strategies. We want to see how we can import them into some of these analysis and some of this action on the global supply chain. So yeah, so I think this is one area which we have not looked so well. We are still novice and learning through this process, but I think we're going to pick up this much more strongly in the next few years and incorporate them into our own work in the global South, which is also to make the jurisprudence, the law, the judiciary interpretation of becoming more flexible and more globalized. I think this is a time where cross-border jurisprudence is actually also exchanged, because I think the judiciary is hardly aware of what are the changes that is taking place in the international law or the conceptualization of this law. So I think that kind of framework would be very useful to do that. We haven't integrated even in India the financial sector, the investment sector to the employment question and to the production question. We are still in the very beginning of that. Krishnendu, you have been a part of this and you know this. This is a very, very kind of weak area in India. Yeah.
Nusrat?
Yeah. So firstly, in terms of the investors, I think that comes back to what I was saying in terms of about hitting their bottom line. If they can't get their finances for their company, it's really going to have an impact. And certainly investors are becoming more, they want to ensure that their investments are ethical investments, and they're realizing more and more that it's really difficult to actually have ethical investments. I have been in contact with lawyers who are building cases against companies who, they say they've actually misrepresented themselves because, they've bought into those companies on the basis that they're doing XYZ and they are ethical companies. And actually, if their standards in practice are not what they've put themselves out to be, then they want to take legal actions for that because they've been misled and their monies have been taken without correct authorization. So I think the investor piece, there's a lot that can be done and is being done. And they've got the buying power, the same as the government here. You've got that purchasing power. So it's really important that they're using it. And I think the tide is slowly changing, as it is with consumers as well. It's slow, but there is a portion of the public who are really concerned. I mean, certainly in terms of the fashion industry, there's a huge environmental impact as well, and that's really impacting things. You know, we're seeing the kind of secondhand clothes market really booming, vintage clothing really booming. But that in itself is not the answer, because if we all buy secondhand, then these workers in these countries will be out of a job. I mean, myself, my family is from Bangladesh, and when I have these conversations about the problems in the fashion industry, there's a lot of people that will say, well, actually, you know, women being able to go and have these jobs in a factory have changed their lives. Women are now breadwinners in their families. You know, it's actually, there's been a real social impact for some people. You know, if you go to the villages in Bangladesh, there's no kids without clothes. There's an abundance of clothes. So there does need to be these presence of these factories in these countries. However, it's about ensuring that they're done correctly. So as a consumer, people are starting to ask questions, are starting to buy you know, more secondhand. Secondhand isn't the answer, but I think as consumers to ask more questions, and you know, it's difficult as a single consumer, but as it becomes a more populist movement, that's where we might see some change.
Chris, he's obviously seen some of the front line with Saida trying to get justice for her daughter's death in Germany and in Italy and so on. What do you think Saida would say in relation to what consumers should be doing, or investors should be doing?
Yeah, I mean, I think similar to Nusrat's point she just made, I mean, I have a direct quote from Saida Khatun, which is, you know, you will not stop buying clothes. We're not asking you to stop buying clothes. To the contrary, we are asking you to ensure that your companies behave responsibly when they operate in our markets. That's just all we ask. And in that statement is the implicit recognition from, you know, an uneducated Pakistani widow who's lost her only son, that of where the power lies, where the power for change actually lies. And so that's what she has said to that point. And I think, I mean, just to be clear on the point of codes of conduct, contracts, and audits, it's not as if this isn't a legitimate means of due diligence. It's just that, you know, this is one of many in the toolbox that we need. It's not that we're against it per se. It's that the priority given to this, as opposed to things like stakeholder consultation, is really, you know, it needs to have its place. And this resource from Shift, which I pasted in the chat, is a very good resource for when companies ask, well, what are we meant to do then in practice? And there are some great examples elaborated in that. And I just wanted to come to the last point, perhaps on finance, as it's been raised, and the Commission's proposal. The Commission's proposal does cover the finance sector, which in and of itself is a huge win. Now, there must have been some fantastic lobbying done by the finance sector to reduce, just for their sector, just for their industry, their due diligence obligations to the point of sale, or just to the first tier, as the analogy would go. So all you have to do when financing, you know, let's say an overseas textile company, say, for instance, would be convinced at the point of giving the credit or the loan that everything is in order. After that, no matter what happens, you continue financing. That's, of course, absurd. We need it to go for the continuation of the loan, because that's where a huge amount of leverage is. We will pull your credit, or we're going to call back our loan if you don't carry out improvements, which are bound to save lives. So yeah, just the last point on the finance point. And sorry, just because Ashim mentioned it, Global South moves in this area. All I have heard of so far of a due diligence law being proposed from the South is a commitment in the Peruvian National Action Plan on Business and Human Rights to bring a legislative proposal in the coming years. So that, of course, raises really interesting questions of, does a Peruvian due diligence law look the same as a European due diligence law, coming from a qualitatively different sector, coming from the other end? And I mean, Peru maybe regionally has quite a few significant parent or lead companies, but it's a different dynamic. And this is an interesting and I think, very appropriate topic for future discussions in constellations like this one.
Well, thank you very much. I think we'll have to wind up there. A very wide-ranging and very interesting discussion. So thank you very much to our panelists, and thank you very much to the audience. I know it's a hot day out there, probably feel like sitting and having ice cream. So thank you for attending. I'd just like to end by saying that here in the UK, we've seen the law stop the UK from outsourcing its obligations under the Refugee Convention to less developed, economically developed countries, and laws must also curtail the UK and other developed countries from outsourcing the most exploitative of industries to these countries, or failing to take any action to curtail them at home. And so we hope in the next few years that important steps are taken to really make effective some of the rhetorical commitment that certainly the UK government has given about stopping some of the worst violations globally. So thank you very much for joining and
thank you, Chris. Thank you, Disrat. And Krishnendu, it was really good.
Thank you all.
Thank you.
Thanks a lot, everyone. Take care.
Bye.